Edward Milwaukee, P5488, appearing on behalf of the people.
Thank you. Good morning, Your Honor. If it please Court Attorney Andrea Fan, P42853, appearing with my client, Mr. Christopher Payne. Mr. Payne, can you state your name for the record?
Christopher Payne.
Thank you.
Attorney Payne.
I'm sorry.
No, I was going to ask if you had discovery.
Yes, Your Honor, I do have discovery. I would just ask that this matter is set for exam.
Okay. One moment. Everything. Don't worry about it now.
Your Honor, if the
It's June 1st at 9 o'clock work.
that date does not work. I thought we were going to be on the 2nd. If we can't do, I can't do June 1st, can we do June the 9th? And my client would be prepared to waive the time frames?
What about June 2nd? That's a little far out.
Okay, June 2nd, what time on June 2nd, Your Honor?
9:30?
I will make that work. Thank you, Your Honor.
Thank you. Mr. Payne?
Yes.
So your exam has been set for an in-person preliminary examination for 9:30 a.m. You understand that?
Yes, ma'am.
Okay, anything from the party?
No, Your Honor, thank you.
Are you on the weekend?
Thank you.
Michael Willis?
Yes, ma'am.
Ready,
Yes, Your
Your
Honor.
ready, Your Honor.
The people versus Michael Jason Willis, 2356870. Mr. Willis is charged with count 1, weapons, firearms possession by a felon, count 2, weapons, ammunition possession by a felon, count 3, controlled substances possession, cocaine, heroin, or another narcotic less than 25 grams, count 4, 5, and 6, weapons, felony, firearm with an habitual offender, second offense notice, except for a probable cause conference day appearances.
Edward Milwaukee, P5488, appearing on behalf of the people.
And good morning, Your Honor. Hugh Marshall, P48269, on behalf of Mr. Michael Willis, who is on the screen. We consent to Zoom for today's hearing.
Okay, Mr. Willis, can you state your full name for the record, please?
Michael Jason Willis, ma'am. Your Honor.
Thank you. Okay, do you have discovery, Attorney Marshall?
I have paper discovery, but in reading through it, I think there may be some digital, so I would need that. So I'm asking for another PCC if that's possible, Your Honor.
Mr. Swan?
Yeah, we're aware of the digital. We are having
inspection.
technical difficulties between us and the police department getting it over. We are working on that.
Technical difficulties that will delay exam date?
Nope, we can't get it, we can get it straightened out. I think it's on their part.
Okay. So Attorney Marshall, I still want to set an exam date. I don't want to delay. In the event that on the day of the exam, you still don't have it, you can make a motion.
Okay.
I can set another PCC if you like. I still say.
Whatever you prefer, Judge.
Okay, so I have an exam date set here for June 2nd. Can you do June 2nd?
June 2nd? Yeah, I can squeeze that in. Could we do it later in the morning? I did a couple of early things.
How about 11:30?
That'd be perfect, Judge. 6/2 at 11:30.
Yes. Mr. Willis, your preliminary examination has been set for an in-person exam for June 2nd at 11:30 a.m. in person at 36th District Court. You understand that? Oh, you're on mute. Go ahead and unmute your device, sir.
Okay, I'll be in contact with him, Judge. I've got his info. Thank you.
Okay.
Have a good weekend.
Yeah.
You got that, Mr. Willis?
Yes, Your Honor.
Okay, you're all set for today. Have a good one.
Okay, have a good one, man.
Mr. Tooks doesn't have to hold on.
He said June the second.
Yeah, I gotta go to 36 district.
Mr. Tooks. Who's representing Mr. Tooks?
Good morning. I am Jonathan Cohen from NDS.
Okay, Mr. Tooks doesn't have any clothes on. Oh, there he is. Okay, let's see. Let's read that. This is without clothes. That's what they're yesterday. Oh, from yesterday. I got you. It's right here. Another. See, anything are set in here. There Armand Wilson present.
Yeah, I'm on Armand. I'm gonna be waiving his presence. He's the 3 co-defendant case that we're all here on.
I'm trying to call it, but I want to make sure everybody's here.
Yep, I'm ready.
Okay, there are 2 other attorneys. Counsel on Robinson is here, and counsel on Jenkins present, Diamond Jenkins. Let me get her on the, so you call, Jefferson. 72957. 72956. Attorney Cook with Attorney Gaddafi, we're gonna call Attorney Jefferson now. Get her on. For English.
Ready, Your Honor.
Case 2356927, the people of the state of Michigan versus Corey English. Mr. English is charged with count 1, weapons carrying concealed, count 2, police officer assaulting, resisting, and or obstructing, count 3, weapons from firearm, set for a probable cause conference, state appearances.
Edward Milwaukee, P5482A, on behalf of the people.
Good morning, Your Honor. May it please the court, Matthew Dupree, P80132, attorney for the defendant, who is here on Zoom. Mr. English, would you state your name, please?
Corey English.
Attorney Dupree, do you have discovery?
I did receive it, Judge. At this time, we're just asking to set for exam.
Do you do June 1st at 9:30?
Let me check that date, Your Honor. Judge, I could not do June 1st at 9:30. Does the court have any availability on the 2nd?
With some patience on your part, yes.
Say that again, Judge.
I said with a little patience on your part, yes. Let's see.
I could also do
9th.
June 5th if that's better for the court.
Yeah, let's do June 5th. They'll still be within the right time frame for my numbers. Let's see. 9:30,
Good for the defense, Your Honor.
June 5th at 9:30. Mr. English,
Yes, ma'am.
your exam has been set for an in-person preliminary examination, June 5th, 9:30, 36th District Court. Understand that?
Yes, ma'am.
Okay, anything else from either party?
No, Your Honor.
Your Honor, thank you, Your Honor.
You're welcome. Have a good weekend.
You as well, Judge. Mr. English, you can log off now.
Good morning.
Good morning.
Your Honor, I have Charles Morris. Mr. Morris, I have not been able to make contact with
I
him.
can't hear what you're talking about to your lawyer, so you can speak.
Mr. Morris is on, but he has no audio.
Oh, okay, good. It showed he had a personal bond, so I apologize.
Okay, I have two people saying that they're on Charles Morris. Attorney Marable, are you on Charles Morris too? You're on mute.
Or maybe he's got retained.
Yeah.
Yes, Mr. Morris retained me yesterday at 4 o'clock, and I filed the appearance this morning.
Thank you.
Oh,
Tanya.
okay. Thanks.
Okay, Mr. Morris, let's see, can you hear me now?
Yes, can you hear me?
I sure can. I'm gonna call your case.
Okay,
Two-
okay. How you doing?
People of the state of Michigan versus Charles Morris. Mr. Morris is charged with 1 count of controlled substance, possession, cocaine, heroin, or another narcotic, 50 to 449 grams, set for a probable cause conference. Appearances.
Edwin Milwaukee, P5482A, appearing on behalf of the people.
Good morning to this honorable court. Carla Marable, P number 62755. Mr. Morris, please state your full name for the record.
Charles Kari Morris.
Good morning. And Attorney Marable, do you have discovery?
I have not got discovery. I was retained yesterday at 5 o'clock. So I need discovery, but I'm pretty sure that we are going to set it for a preliminary exam.
Okay. The week of June 5th. Does that week work for you?
Could we have that next week, the 7th or the 8th?
Yeah, that's fine. Let's see what
The
that.
7th? Yeah.
The 7th at, let's do 10:30. You do 10:30?
That'll be fine.
6, 7, 2. Okay, Mr. Morris,
Yes, ma'am.
so your exam has been set for in-person exam at 36 District Court for June 7th at 10:30 a.m. You understand?
Yes, ma'am.
Okay. Anything else from the party?
No, Your Honor.
No, Your Honor. For the prosecution is gonna email me the discovery today.
We are gonna, yeah.
Okay, thank you.
And 62755.
Yes, 62755 is my P number. Carla Marable, Marable.
Thank you.
Thank you.
Good morning, Judge.
Morning.
Judge, I'm checking in on Sean Taylor that was scheduled for competency today. He is in the Wayne County Jail. And first off, I need to know, has the court received a competency report?
We have not. Update May 30th. We'll have an update coming May 30th from the president.
So we expect to know something on the 30th?
Update, the person who usually handles it is off until May 30th, so they said she'll give me an update. So honestly, Judge, I don't know exactly what that would be.
So they didn't specify if that's a report or if it's an update. Is this your client right here on the, let's see, to the gentleman on the Zoom with the Wayne County Jail 8th floor icon, can you open your device and state your name, please? To the gentleman sitting in the Wayne County Jail. What's your name, sir?
That is him. That is him.
Okay, let me call the case. This is case 2206039, people of the state of Michigan versus Sean DeAndre Taylor. Mr. Taylor is charged with count 1, unlawful imprisonment, count 2, police officer fleeing third-degree vehicle code, count 3, weapons carrying concealed, count 4, weapons carrying concealed, count 5, police officer assaulting, resisting, and obstructing, set for a competency hearing. Appearances.
Edwin Milwaukee, P5482A, appearing on behalf of the people.
I need a moment, Judge. Good morning, Your Honor. Carol Collins, P 56805, on behalf of Mr. Sean Taylor, who is present from the jail. State your name for the record.
Thank you. Okay, and Attorney Collins, as we just stated off the record, the forensic center contacted the court, said they need until the 30th for an update. I'm not sure if that's a report or if that's just. But I would like to just go ahead and set this for the 30th so we can see what that would be and move from there.
Judge, I will check. Yeah, I will check in with the court on the 30th. That is a terrible day for me, but I will, if we get the report, I ask that it could be emailed to me, but I will check in with the court. And I would also ask the court for a breakout room with Mr. Taylor before I sign off.
Okay. You can log on the 31st if that makes it easier.
Yeah, that'll be better, Judge. I'll check with the court on the 31st.
Okay, we'll do 9 o'clock and go from there. So I'll put you in the breakout room with your.
Thank you, Judge.
Attorney Gator Robinson.
Yes, Your Honor. Good morning.
Good morning.
I am ready on Ms. Keelium.
Okay, this is case 2356864, the people of the state of Michigan versus Chanel Kellum. Ms. Kellum is charged with count 1, weapons carried concealed, set for a probable cause found for experiences.
Edwin Zawaki, P 548. Excuse me. Hearing on behalf of the people.
Attorney Phyllis Gayton Robinson on behalf of Ms. Kellum. Ms. Kellum, can you please state your name for the record?
Chanel Kellum. And do you have discovery?
Yes, Your Honor, I do have discovery. I am asking that this matter be set for exam.
Okay. Does anything in the week of June 5th work?
The week of June 5th, one moment. The week of June 5th. Yeah, Your Honor, may I do June the 5th? Can I do it later in the morning? I start over at Frank Murphy.
Let's see. How about 10:30?
That should work just fine, Your Honor.
Okay. Ms. Kellum?
Yes.
Your exam has been set for an in-person preliminary examination at 36th District Court for June 5th at 10:30 a.m. Do you understand that?
Yes, ma'am.
Okay, anything else from you, the party?
No, Your Honor.
No, Your Honor. Thank you. I want you to have a wonderful weekend. Ms. Kellum, I'll talk to you soon.
Okay, thank you.
Thank you. We're going to handle Tooks and then handle the 3 defendants with Jefferson, Vidal, and Cookworth. So Jerome Tooks first, case 2356853, people of the state of Michigan versus Jerome Tooks. Charged with count 1, controlled substances possession, cocaine, heroin, or another narcotic less than 25 grams, set for a probable cause found for experiences.
Edward Zawaki, P 54828, appearing on behalf of the people.
Good morning, Your Honor. Neighborhood Defender Service by Jonathan Cohen, P 86151, appearing by Zoom with Mr. Jerome Tooks, who's present by Zoom. Mr. Tooks, can you please state your full name for the record?
Jerome Tooks Jr.
Okay, and Attorney Cohen, do you have discovery?
I do. Thank you. We just asked for an examination date.
Okay. Same thing, anything available the week of June 5th?
June 5th, I have later in the morning, June 5th, 10 a.m. and on, the 7th, the 8th, the 9th. Yeah, pretty much 5, 7, 8, or 9, if you have a 10:30, 11, 10 o'clock, anywhere in there.
Let's do June 7th at 10:30.
June 7 at 10:30 in person. Okay.
Okay, Mr. Tooks, your exam has been set for June 7th at 10:30 a.m. Do you understand that? Mr. Tooks?
Yes, ma'am. Yes, ma'am. I understand. My mic
Okay,
is
that'll be
muted.
in person at 36th District Court, okay?
Okay.
All right, anything else from either party?
No, Your Honor.
No, thank you, Your Honor. Have a good day, everyone.
Thank you too. Okay, now to Robinson, Wilson, and Jenkins.
All right, I got you, good Lord. So I shot.
Okay, we're on the record. This is people of the state of Michigan versus Armand Wilson, who was defendant number 1, Elijah Javante Robinson, who was defendant number 2, and Diamond Monet Jenkins, who was defendant number 3. All defendants are charged with count 1, assault with intent to murder. Defendants 1 and 2 are charged with count 2, weapons, felony firearm. All defendants charged with count 3, assault with intent to do great bodily harm less than murder or by strangulation. Defendants 1 and 2 both charged with weapons, felony firearm. All defendants charged with count 5, assault with a dangerous weapon, felonious assault. Defendants 1 and 2 charged with count 6, weapons, felony firearm. Defendants 1 and 2 charged with count 7, assault with intent to murder. Defendants 1 and 2 charged with count 8, weapons, felony firearm. Defendants 1 and 2 charged with count 9, assault with intent to do great bodily harm less than murder or by strangulation. Defendants 1 and 2 charged with the remaining counts 10, 11, and 12 with weapons, felony firearm, assault with dangerous weapon, felonious assault, and weapons, felony firearm. With the habitual for the second offense notice for defendant number 3. Set for a probable cause conference and appearances. It's Wilson, Narcissi.
Okay.
Don't use fight and aim.
AP Intercession, are you ready to go on record? Can defense counsel put the appearances on?
Neighborhood Defender Service by Jackie Pilkowitz, P81653 on behalf of Armand Wilson, who is present.
And Your Honor, Jahad Kadaf, P82492, appearing on behalf of Elijah Robinson.
Mr. Elijah Robinson and Mr. Wilson, state your name for the record, please. Unmute your devices.
Armand Wilson.
Thank you.
Watson.
Say your name one more time, Mr. Robinson. Mr. Robinson, state your name again. I couldn't hear you.
You breaking up. Elijah Robinson.
Thank you. And Attorney Jefferson.
Okay, I'm sorry. Good morning, Your Honor and staff. Thomasine Jefferson on behalf of Diamond Monet Jenkins.
And have you been in contact with Ms. Jenkins at all?
No, Your Honor, I have not.
Okay. All right, does everyone have discovery?
Your Honor, as it relates to Mr. Robinson, I just checked and it was just downloaded. I have paper and video that were sent over to me.
AP Intercession, we can't hear you. Your audio is not. It says you're unmuted, but I can't hear anything you're saying. Okay.
Ms. Jenkins.
Diamond Jenkins? Okay, thank you.
Hi, Judge, can you hear me?
Can hear you now. Thank you.
Okay, great. Judge, I did not send discovery to Ms. Jefferson because when I checked, well, I guess ROA for all intents and purposes, I didn't have a name of the defense, so I will send that discovery on right now.
Okay, and Attorney Jefferson, I just received information that your client is in county jail. Attorney Jefferson, did you hear? Did you hear me?
Sorry, I couldn't hear.
Your client is in the Wayne County Jail.
Okay, yes. And are they coming on?
Let's see, I'm going to bring out jail and see if they have her. And AP Intercession, I didn't even get your appearance because we can hear you.
Sorry, Laura Nersessian on behalf of the people, P67104.
Thank you. Okay, any other discovery discussions that we have today?
Your Honor, I'm in receipt of paper discovery. I believe digital was sent and uploaded yesterday. So if I'm missing anything specific, I will contact Ms. Nersessian in advance of the exam date.
Okay. So let's get to a date then for exam. If Intercession, do you see this taking more or whole afternoon?
I do, Judge. I would ask that this be put in the afternoon.
Okay, that's what I thought. Let's see there. So the week of June 5th, where I'll start, see what everyone has available. We can do that Monday, June 5th at 1:30.
Judge, I'm actually, I'll return to work on June 6th, so I would have the afternoon of June 6th, 7th, and 8th, if that's possible.
Your Honor, I'll jump in. I'm in trial the 7th and 8th. My preference would not be to do it the afternoon of the 6th before a jury trial, but if that's what it comes to, we can do that.
I could also do the afternoon of June 9th, that Friday.
So I'm not available June 9th or June 6th or 5th for that matter. Thank you.
What day are you available?
I am available June 8th.
Attorney Gadot, what about you?
Your Honor, I'm actually in downtown on 5th, 6th, 7th, and 8th. The afternoon of the 8th, I don't think would be the best time, but I should be wrapping up a hearing. But I understand that sister counsel's in trial on that day. I don't think that date's going to work. Given the severity of the matter, and I don't know if the other counsel will agree with me, additional time to review discovery video. It appears to be a complex case. If the parties all agree, we can possibly push this to the week of the 12th, but I can't speak on behalf or the court.
I would join in that request. I'm available anytime 12, 13, or 14.
I concur.
Okay.
I concur.
Judge, I'm just not available on the 14th or 15th.
All right, okay, great. The 13th at 1:30?
Yes, Your Honor.
That's fine.
And let's see if your client, Ms. Jenkins. Good morning, Deputy.
Good morning, Your Honor. I just got one more for you, but I'm just waiting for him to come off the elevator.
So it's not Ms. Jenkins, is it?
Yeah, Diamond Jenkins.
Oh, yes,
Damon.
Diamond Jenkins, okay. So we're on that case right now on the record. Attorney Jefferson, do you just need to speak to your client or do you want your client on the record?
Yeah, I would, if he's come, I don't know how much time they need for him to get off the elevator.
What I'm saying is we can go off the record, everyone can move on and you can just wait for him to come up if you want to talk to him. If you don't need him to go on
No,
the
I'll
record.
wait till, we can go on the record and then I'll talk to him afterwards.
So you want us to all wait for him to come up?
No,
Are you
no,
Jenkins?
Judge.
I need Jenkins. Jenkins.
Oh, okay. Okay, there we go.
Okay. Can you say your name, please?
Diamond Jenkins.
Thank you. Okay, so Ms. Jenkins, we just set an exam date for June 13th at 1:30. It'll be in person at 36 District Court. Which only thing that you missed was that everyone has discovery and that everyone's ready to move forward to hold their exam. Okay?
I'm sorry, can you repeat that for me? I didn't hear you.
Everyone's moving forward and ready to hold their exam on that date of June 13th at 1:30 in person at 36 District Court. Okay?
Yes, ma'am.
And
So,
Ms. Jenkins, I'll be there to see you this weekend. Thank you. I'm sorry.
No. I was gonna say, do you want to talk to her in a breakout room?
Yes.
Okay, so we're off the record here, but there's nothing else anyone needs to discuss.
Thank you, Judge.
Thanks, Judge.
Thank you.
Armand, you can
Thank
hop
you.
on the video call.
Okay.
Mr. Robinson, you're all set. You can log up too. Mr. Stable.
Okay.
Council, Mr. Staples, can you hear me?
Mr. Rahman.
Good morning.
CR438 trying to get you on TV.
We are waiting for your lawyer. So as soon as your lawyer shows up, I can call your case, okay?
Okay, Your Honor.
Just hold tight.
Okay.
Get it back to
Okay. You need to sign that or no? I'm sorry. Okay. The waiver judge signing. You all set, Attorney Jefferson?
Yeah, I'm done. Thank you.
Have a good weekend.
how far is she into the we know the term is now.
I know it works. Sorry about that. Okay, you're all set, Ms. Jenkins.
Okay, thank you.
You're welcome. Have a good day. Yeah, we do. Does anyone have a record? Wayne Cook, the first person. I don't.
Excuse me, Court. Excuse me, Judge Sabree.
Yes.
Ma'am, that's all we have for you this morning.
Okay, thank you. Have a good weekend.
You too, ma'am.
Thank you. Okay. How are you doing today?
Good, how are you?
Good. Ready to go on your case?
We are. Do you want us to step up? Please?
Yes. Okay, we are on the record. This is people of the state of Michigan versus Rakaya bin Abdul Rahman. Ms. Abdul Rahman is charged on case 1961512 with one count of operating while intoxicated, residence notice set for an exam today. Appearances?
Good morning, Honor. Daniela Parrish on behalf of people, PA 5495.
Good morning, Your Honor. Spencer Clayton speaking on behalf of the defendant who stands to my right, number 77302. May you state your name for the record, please?
Aliyah.
Okay, I have a waiver form before me. Is it correct? Attorney Spencer, your client's waiving her exam today?
It is, Your Honor. I've explained to her her right to have a preliminary exam, what people would have to prove, and the standard of proof that they'd have to prove that to. I believe it's her wish to have this case found over the circuit court waiver, right to preliminary exam.
Any objections from the people? No objections. Okay, Mr. Rahman, I'm going to ask you some questions. If you don't understand me, or if you can't hear me, let me know, okay? Yes. Is it your wish to waive your exam today? Yes. You understand that you have a statutory right to an exam today? Yes. And then by waiving that exam, that means that people do not have to present any evidence today at the probable cause standard, which is a lower standard in criminal law, but still a standard. And they would have to prove that one charge I read off today, if you were to demand that exam. You understand that? Yes. And then by waiving your exam, they do not have to do that today. You also understand that you're not waiving your right to trial? Yes. Did anyone force you or threaten you to waive your exam? No. Did anyone promise you anything? No. You have any questions? All right, I find your waiver to be freely understanding and voluntarily given. I will have you bound over to Third Circuit Court, Frank Murphy Hall of Justice, for arraignment on the information. It'll be 2 weeks from today, June 9th at 9 o'clock. Okay. Anything else for you, Department?
Your Honor, may I address bond? Sure. Your Honor, she's currently on a tether. She's been on there for approximately 2 months, no violations whatsoever. She's had some issues. She said they have it adjusted several times. Irritating her skin. I would ask the court to consider possibly putting her on testing, certainly with the nature of these charges. She understands the court is going to want to monitor her sobriety and ensure that it's ongoing. I'd ask the court to consider possibly putting her on ECG perhaps 3 times, 4 times a month. Work, but certainly continue to monitor her satisfactory and they'll be able to. Yeah, sorry. I think the court can still monitor her sobriety without the inconvenience of the tether. Again, she has been out 2 months, so I think that's appropriate.
6'2".
I understand the needs of the tether, but people just objected to indicate that at this time, we believe that.
Okay, thanks.
Is the alcohol better?
Are you working?
Yes.
Teacher, you're right.
What do you do with something?
No, I'm an artist, I do customer service as well.
Okay.
I thought you told me you were a teacher. I misunderstood her, Your Honor. I apologize.
Okay, so I will adjust the bond. Allow for the tether to be removed, but you have to test. The question is, so it has to be random. We'll figure that out for record as far as, and I will agree at least 3 times a month. I have to write it up to be very specific. I want to make sure that you see the terms. Or you do what you have, what you're not. Okay? Okay. All right. Anything else?
Go ahead.
Robert? Are you here for, Attorney Kennedy, are you here for Mr. Staples?
Yes, Your Honor.
Perfect, okay. Yes, sure. People of State of Michigan versus Lieutenant Staples, charged with charge on case 2356950 with count 1, weapons, firearms, possession by felon, count 2, weapons, felony firearms, second offense, count 3, weapons, firearms, possession by felon, count 4, weapons, felony firearms, offense, count 5, weapons, firearms, possession by felon, count 6, weapons, felony firearms, second offense, count 7, weapons, firearms, possession by felon, count 8, weapons, felony firearms, second offense, count 9, weapons, firearms, possession by felon. Count 10, weapons, felony firearms, second offense. Count 11, weapons, ammunition, possession by felon. Count 12 and 13 and 14, weapons, ammunition, possession by felon, as well as count 15 with the habitual offender fourth offense notice set for a probable cause conference today. Harrison.
Good morning, Honor. Daniela Parrish on behalf of the people, P85495.
May it please the court, Neighborhood Defender Service of Detroit by Jeffrey Konecki, P64800. Behalf of Mr. Staples. Mr. Staples, please state your name for the record.
Taylor Staples.
Okay,
Your Honor, we wish to set this, I'm sorry, Your Honor.
go right ahead.
We wanted to set this for a preliminary examination. I believe I noticed last night we received paper, but we still need digital discovery.
That is correct, Your Honor. According to AP Salaki's notes, the people currently do not have any digital. We have reached out to the OIC, so if defense wouldn't mind kindly just emailing myself and APA Salwaki if he does not receive it in the next holidays here, but by Tuesday, email us and then we will also recontact the OIC.
No, if I don't have it by beginning of next week, then yeah, I'll reach out and let you know.
I appreciate that. Thank you so much, sir.
Okay, Attorney Konecki, do you have June 2nd or June 6th available?
I could do June 2nd. It would have to be after 11. I have one at 11:45 before Judge Jefferson, and I have a 8:30 pretrial in Frank Murphy.
You want to, okay, tell me what time you want.
Does 11 o'clock work for the court?
That's fine.
Okay, that works great. Thank you.
You're welcome. Okay, Mr. Staples, your exam has been set for an in-person preliminary examination at 36th District Court for June 2nd at 11 o'clock a.m. Do you understand that?
Yes, Your Honor.
Okay, anything else from either party?
Nothing for the people, Your Honor.
No, Your Honor. Thank you. Mr. Staples, we'll talk once I get all that discovery, okay?
Okay.
All right. I'll see you soon. Thank you, Your Honor. Everyone have a good weekend.
Well, thank you.
Bye.
We'll log on to jobs. Attorney Hamilton, good morning.
Morning.
Let's see, let me turn up the volume here. Okay, let me call up, you're on. On Cook and Earl. Okay.
Correct.
All right. This is the people of the state of Michigan versus Dwayne Cook, case 2356959. Mr. Cook is charged with count 1, weapons carrying concealed, count 2, weapons firearm, possession by a felon, count 3, weapons firearm with individual offender, second offense notice, set for a probable cause conference. Today appearances.
Good morning, Your Honor. Daniela Parrish on behalf of people, P85495.
And good morning, Vanessa Hamilton, PA2107 on behalf of both defendants. Your Honor, I have just gotten out of a trial as of this morning. I have not been able to make a first contact with them. I was wondering if we might be able to waive appearance and possibly set a preliminary exam date or an adjourned PCC date, whatever the court's pleasure is.
I'll set it, let's do an exam date. I'll set it, it's set for the 31st, but I'll set it out a little bit further to give you time to find your client.
Thank you.
So for Mr. Cook, let's see, do you have June 8th available?
Yes.
All right, how about 9 o'clock or 10:30?
Can we do 10:30?
Okay. All right, June 8th at 10:30 for Mr. Cook. Let me call to the matter. People of the state of Michigan versus Charles Earl. Mr. Earl is charged with on case 2356592, charged with 1 count of police officer fleeing forfeiture vehicle code, set for a probable cause conference as well. Appearances.
Good morning, Your Honor. Daniela Parrish on behalf of people, P85495.
Hey, good morning, Your Honor. Vanessa Hamilton, PA2107 on behalf of Mr. Earl. Your Honor, same as before, I have not been able to make a first contact with him, but I'd asked to waive his appearance and set a preliminary exam date.
I will waive his appearance. Do you want to set it for the same date?
Yes,
June
that's
8th?
fine.
Okay, we can just set it for the same time. Whoever you want to go first is fine.
Okay, thank you.
Okay, so it'll be June 8th at 10:30.
And then Judge, I do, in Judge Giles' courtroom, I do have Terry Peterson, but when I was in there earlier, he had not appeared. Do you know?
He has still not appeared. I just looked on the Zoom icons and there's no one left.
Okay.
You want me to log back on there and waive his presence so that you can get that done?
Yes, if that would be possible. I'll switch over there.
I'll log on right now.
Okay, thank you.
Case 35668 people of the state of Michigan versus Arthur Brown. Charged with count 1 and count 2, assault with a dangerous weapon. Count 1 and count 2, assault with a dangerous weapon, felonious assault. Count 3 and 4, weapons, felony firearm, set for exam. Appearances.
Edmonds, Milwaukee, P54828, appearing on behalf of the people.
Good morning, Your Honor. Dennis Whitey, P79560. Behalf of Mr. Brown, who is present and standing in the courtroom, please state your full name for the record.
Arthur Brown.
Morning. Thank you for your patience. A little long warning. Is everyone ready to proceed?
Yes, Your Honor, we are ready to proceed, and we will be attempting to add 2, or actually a total of 4 other charges. Assault with intent to murder and weapons, firearms discharged from a vehicle, as well as the, excuse me, 2 weapons, felony firearm charges that will go along with it.
Judge, for purposes of the record, defense would waive this exam. However, the people are still demanding it. That's what's being held.
That is true.
Okay. Anything else preliminary?
No, Your Honor.
Nothing from defense, Judge.
There's anyone on YouTube or Zoom who may testify in this case, now is your time to log off, as well as if there's anyone in the courtroom who may testify, now time for you to leave the courtroom. Call you first.
People called Charlie B. Brown.
I'm sorry. There's no answer. I was trying to get you. Did not answer. He might have. Raise your right hand. You swear to tell the truth, no truth, and nothing but the truth. The door opens right here in the front. And that mic, the speaking mic that's sitting on the ledge, just make sure you speak up instead. Whenever you're ready, Mr. Sawaki.
Sir, could you state your name for the record, please?
Charlie B. Brown, third,
And what brings you here today?
hearing on this shooting involved in my family.
And did that incident occur on January 15th this year?
Yes, sir.
And did that occur at or near Finkel and Grand River in the city of Detroit, County of Wayne?
Yes, sir.
What were you doing at that location on that day?
We were driving down Grand River and I think maybe my cousin was coming out from a restaurant and we proceeded to get to the light on the service drive. So we made eye contact at the light.
Once you made the eye contact, what happened?
Can you clarify who you're saying, we?
My wife is in the truck with me.
My apologies, Your Honor.
So when we got to the light, we made eye contact, by him being on the driver's side of the truck, which he's driving, I'm on the right side. I let my window down and he let his window.
Now, which side is his vehicle compared to yours, left or right?
He's on the left side of my vehicle.
Okay. And what happened then?
So he let his passenger window down.
Okay.
So, and I let my driver's window down. So we are talking from car to car. So once the argument got kind of heated, when he was like, pull over, get out the car, I jumped out the truck
You said heated. What do you mean by heated?
Well, it got kind of aggressive because we were arguing over, the dispute is really over land. And we was arguing about the land down south. So when the dispute got kind of heated within the argument, when he announced like, get out the truck, let's talk.
Who? Did you get out of the
I
truck?
got out my vehicle.
Okay, what did you do then?
When I got on my vehicle, that puts me on his passenger side. I'm at his passenger door.
Is the gentleman who you were having a conflict with here today in the courtroom?
Yes, sir.
Did you point him out and describe a piece of clothing that he may be wearing?
That's my cousin right there, the shirt, the black and gold shirt.
Let the record reflect that the witness has identified the defendant. Okay, you're out of the car and you approach his car. What happens next?
So when I approached the driver's door, we still arguing, but I'm standing outside of his car.
Let me ask you this. Are you armed at this point?
No, sir.
Were you ever armed that day?
No, sir.
Okay, you approached the driver's side.
Passenger side.
Passenger side, thank you. And you're having a discussion with him, I understand?
We are still arguing.
Okay. What does he do?
When I get out there, as I'm looking into his vehicle, I can see that he has a weapon in his hand, but it's not, he didn't lift it up, but I can see the gun.
Okay, it's in his hand?
Yeah, he has it down by the console.
Could you give us a brief description of that weapon?
It looked like a Glock, not a revolver, but a semi-automatic.
And what happened next?
Once I see the pistol, then I'm kind of giving myself, protecting myself, putting myself in between me and the passenger of the car. So he can't really, we still arguing, but I'm looking like watching the gun and I'm arguing at the same time. But I'm trying to keep myself out of the line of fire too at the same time, because he has a passenger in the car. So now, once we start arguing more, I see the weapon now.
Okay, does he point the weapon at you?
Now he has it up, and that's when I told him, I'm like, you ain't gonna do nothing with that.
Okay, when you say up, he has it up. Exactly, describe in your own words exactly what he's doing with the weapon.
He has it, first it's down by the console. So now when I say up, he lifts it up more, I can see it now.
Okay.
Because I'm standing outside the car, so I can look down in the car at an angle. I'm looking down in the car from an angle.
Let the record reflect that the witness with his
Right hand.
right hand, thank you, is lifted the pantomime to lift up the weapon to face level. His
Yeah, I
face
can
level.
see it now.
Okay? So he's lifted up the weapon. What happens next?
So now that's when I proceeded to argue with him, like, you know, like, what you gonna do with that? And I think I might have started pounding on his car. Like, get out the car with that, you know, like, get out the car with that gun, cause now I'm like, okay, I see the weapon, but I got my wife in my truck, and I'm trying to protect myself at the same time, but I'm actually watching his female passenger, because he cannot really get a shot off unless she leans back, because she is right side by side with me. And we still arguing with this gun up, right?
The gun's up, does he point the gun at you?
Yeah, he has it at me now, because I'm at the window.
Okay, what's he do with the gun next?
At this point, he tries the maneuver of shooting and pulling off, I would say at the same
Okay.
time.
You say, did he actually fire the gun?
Yes, he actually shot. He shot twice.
Twice. Do you know where the bullets go? Went.
The first round went into the hood of my truck, which went right at my wife. Because I'm on my driver's door. And it hit like right up at the windshield, not down by the front of the truck. The bullet went right at the like the windshield wiper of the driver's side. That's what it was going in at.
Okay.
So it's in between, it's like missing me, but it's at my wife.
Okay, where did the second, do you know where the second bullet went?
The second round, he missed. He shot it, but he just missed. Second round missed the vehicle, missed the security, but he shot the second time. Shot twice.
Where did you observe the defendant point the gun?
When I was standing outside the car.
Where? Not when, where? Maybe I did say when, I didn't. Where did you observe the defendant point the gun?
As he's trying to pull off.
Okay.
He's trying to, because we side by side. In order for him to pull off, he has to ease up and get his vehicle around my vehicle.
Okay, let the record reflect that, witness has indicated with his right hand that the defendant's vehicle was trying to maneuver his vehicle in front of his vehicle and to the left, correct?
To the right. He's trying to make a right turn.
Okay, he's trying to make a right turn.
Right.
Can I ask a clarifying question?
Yes, ma'am.
Did he point the gun at you?
When I got out the vehicle?
No, when he was shooting.
Yes, ma'am.
Any questions based off of that?
No, Your Honor.
I'll save mine, Judge.
Okay. Actually, I do have a question. So the defendant actually did point the gun at you before he fired, right?
Yeah, we got it. What I'm saying is this, he has to raise the gun because the passenger is sitting next to him. He has to lift the gun up to, in order to shoot out the window.
Okay.
You gotta shoot out the driver's window.
And he was pointing it at you.
Right.
Okay.
It's just
And
a
then,
left. It's just
let me ask a question. And then, he drove off, correct?
Yeah, after he shot twice, he sped up.
I have no further questions, Your Honor.
When my client drove away or attempted to drive away, you weren't at the passenger window, were you?
When he attempted to drive away?
Correct.
When he attempted to drive away, I dove out the way. I'm near my truck. As he drove away, 2 shots went off. So I'm getting back in my way and I'm checking on my way.
So it's your testimony that you were beside the passenger, you were at the passenger window, shots were fired, and you were simply diving out of the way of the shots. Is that correct?
No. I was standing at the passenger window. When the gun is shown, and we are still arguing, when the shot was taken, when he took that shot, he has a female passenger in the car.
Yeah.
The female had to lean back in order for him to get the shot off. That's how I was able to see her. I'm looking at this lady's body. It's in my statement. I see her. He's talking to her. He cannot get that shot off unless she leans back.
Did she lean back?
Yes, ma'am. I put it in my statement.
Oh, great, and I'm glad you brought up your statement. You gave a statement to the police after this incident, is that correct?
Yes, ma'am. Yes, sir.
Were you truthful in that statement?
Yes, sir. Up to my best ability, yes, sir.
Okay. Fair to say that your memory then was better than it is now of the incident?
It'd be the same.
It's the same. Okay, well then let me just ask straight up. In your statement, and please confirm if you made this statement, I'm mad as hell because he wasn't in no threat. I got my wife sitting in the truck and my daughter was at home, thank God. He proceeded to try and angle the car towards people going south. As he does so, the car moves, so now I'm at the back door.
Yeah, that's because we were fighting. I'm mad because the incident would have been a fight.
Did you say that in
Not a
your statement?
shooting.
Sir, the question before you is, did you say that in your statement?
Yeah, that was because.
Okay,
we
fair
were-
enough.
Because
Let me
we
move
were
on
into
then. I started beating on the back windshield.
Listen, like I told him, I'm at the side of the car. I just said, I think I started pounding on the top of the car. When the car moves, that puts me at the back after he shoots.
Okay.
That's how I end up at the back windshield, because as he's pulling off, the car has to move. Now, when the car moves and I'm still standing in the same position, I never moved, the car moved. So now I'm at the back windshield. Once he tries to pull off, that's when I mentioned that I got to the back windshield because the car he's driven off.
So let me clarify.
I'm still standing in the same position, sir.
Okay, so let me clarify your testimony. When the first shot was fired, you were still at the passenger window, correct?
The first shot was fired, and yes, I'm like outside my car. He's trying to do, he's trying to shoot and pull off at the
Sir, I
same
don't need all
time.
the explanation. I just need to know, when the first shot was fired, you were standing outside the passenger side of the car, correct?
Yes.
Okay.
I'm outside.
So again, you gave a truthful statement in this case, so I want to make sure to confirm that you actually said this, okay? I'm gonna start back where we were. He proceeded to try and angle the car towards Finkel going south. As he does so, the car moves, so now I'm at the back door. I started beating on the back windshield because I'm pissed. Fuck that gun. I told him, nigga, you're gonna have to kill me tonight. He shot the first shot and went towards my truck. Fair enough to say that you were not actually at the passenger side when the first shot went off.
You're wrong.
Okay, so who's wrong? Your statement back then or your statement now? Which
I'm
one's wrong?
saying, my statement is accurate. When these shots went off, the shots went off, sir. I'm not I'm fearing for my life at the same time. So I'm not saying I'm standing there like that. Like I'm sitting here like, no, I'm moving. When the female moved, I knew to move. I've been in the military. So when I watched her body language, when she moved so he could get that shot off, I'm thinking to myself, okay, let me kind of get back because it all happened simultaneously.
Okay, so I just asked you the question, were you at the passenger window when the first shot went off? You stated yes. Now are you changing that testimony
No,
to say
I'm
you're at
not.
the back of the car?
No, you said, the back of the car is the car pulling off, sir. I just told you that. When I mentioned I'm at the back of the car, I never moved. The back of the car, meaning your vehicle moved. He's pulling off. So if I'm standing here and the vehicle is pulling off, that's how I got to the back of the window. Once I looked up, all I see is the back of the windshield after these shots.
So you're at the back of the car, but you had enough time after being shot at to beat on the back windshield, right?
No, that was, he didn't, when I was beating on the back windshield, sir, that I was outside the car. At the same time when he's pulling off, he shot when I was beating on the hood of the car. That's when he proceeded to pull off and shoot. He tried to pull off and shoot at the same time.
When you say the hood, you mean the trunk or the?
No, the top.
Oh,
I'm at the passenger side, so I'm at the top of the car.
Okay, so you're mounting.
I'm above the passenger.
Fair enough. And you're above the passenger, so you're
Right.
standing, right?
Yes, I'm standing.
You're standing, you're yelling, right?
Yes, sir.
You're pissed off, right?
Yes, sir.
Call him a nigga and everything, didn't you?
No, I mean, we might have called each other both.
Okay, fair enough.
This is an argument.
And when you did, okay, it's a heated argument, right?
Yes, sir.
And when you did that, you obviously were upset, correct?
Yes, sir.
And you had told him at one point, you're gonna have to kill me, right?
And him?
Correct.
When I seen the gun, once I seen the gun, sir, I'm protecting my wife. Now I got a passenger. I have a
Fair enough.
family.
I just asked, you told
At
him.
that point, when I seen the gun,
I'm not asking you.
At that point, when I seen
I'm not
that
asking
gun, I might have said anything.
I'm
That's
not
what I'm
asking
telling
that.
you.
Thank you. I'm not asking that. What I'm asking you is, did you tell him at some point during that altercation, I told him, nigga, you're gonna have to kill me tonight? And then he shot the first shot.
I don't remember. But in this preceding argument, I might have said anything.
Okay, fair enough, but
Yeah,
fair to
I
say
don't-
this statement's accurate, is that correct?
Yeah, it might, yeah. I might have said anything to him before the shots went off.
Fair
That's all
enough.
I'm telling you.
You agree with me that he couldn't speed off, he had to work around your motor vehicle to get away, is that correct?
I didn't really have to work off. He just eased up and pulled off because he has a lot of room. He can go out in the
Okay.
field.
So
That's what he did.
he eased up, which gave you time to beat on the car a little bit more, right?
That's what happened. That's all that happened.
Now, after that, is it your testimony that you were in fear that day?
Yeah, I was in fear of my life when I seen the gun, but I wasn't scared to the point where I don't have common sense to do action.
Yeah,
to take the actions to take when I'm in fear. Do you hear what I'm saying?
Okay,
I have
so
been
my
there.
next,
Let me explain something to you.
no, there's no question before you at this point. You've answered it. Here's the point, okay? If you're so scared, didn't you in fact follow or try to chase him home? Meaning my client, you tried to chase him home, is that correct?
No, I went to the second precinct.
Okay, so let me ask again about your statement since it seems to change. Understand? The first thing says this, I'm standing outside my truck at the back of his car. He's shooting across the female's face. He gets past my truck, shoot again, then he flee home. I gave chase a couple of blocks, but but I had to check on my wife and truck, so I pulled over to call my brother. Fair to say you actually chased him, right?
Fair to say I chased him because I didn't have a gun.
Okay, so
And that's fair to say that in a situation like
your
that.
testimony earlier was inaccurate, correct? You did in fact chase him, right?
Huh?
You did in fact chase my client after this incident, correct?
I chased him, we going in the same direction. I'm not chasing the man with a gun, sir. No. I'm not
Okay.
chasing the man with a gun who just shot at me. You don't make sense.
Yeah, I know, most people would go the other direction, right? But you don't. You actually went
I
after
went
him.
in the direction of the precinct my brother sent me to, which is the second precinct. My brother's
Okay.
a police officer.
Fair enough to say that this, let's talk about family and police officers then. Fair enough to say that you conveyed, well, let me just back up.
Go.
This is all over a land dispute in some southern state, correct? Over probate court or something regarding family land plots,
I
correct?
said that.
I understand, I just confirming that's correct.
I'm sorry.
Okay, fair enough. And so, that's why all this animosity exists is because this land plot, correct?
Basically.
Okay, and didn't you convey a message to get back to my client that if he would just give you the piece of land, you wouldn't show up to court today and you wouldn't follow through with charges? And you're under oath. Before you answer that question, think very carefully.
Did I convey with
Listen to
somebody
me.
else?
Yesterday, did you make that statement?
All right, no, sir.
Judge, your argument.
Yeah, what did you, what?
There's an objection.
Oh, I'm sorry. I'm sorry.
I don't think it's argumentative. It goes to a witness's bias. I mean, hell, he's sitting there using this criminal matter to make a civil gain. I think it's a totally appropriate question.
And you already answered. I'm sorry, go ahead.
I mean, it's an argument on both sides, actually, because they're shouting at each other. So-
You know, it is loud, but on the other end, I can actually hear it. So I'm sorry. So I'm trying to balance between argumentative and them just being loud right now, because I can actually hear the testimony and the questions for the first time in a very long time. At any point, I will allow you to object.
Okay.
But I actually appreciate the value.
I understand that.
I'm sorry, wrong too.
It's not bothering me, but if the prosecutor's gonna object, we have to address it.
Oh.
That's fine.
Just 1 minute, Your Honor. Don't answer this question when I ask it, because I'm sure there's gonna be an objection, okay? Have you been convicted of any assaultive crime in the past 3 years?
Objection.
Judge, this is a self-defense case, so everything he's testified to is he's the aggressor, and that goes right to the heart of the Self-Defense Act, or what's commonly known as stand your ground. I think it's relevant, what any criminal history, actually not any criminal history, just assaultive criminal history, that the complainant would have and that others would be aware of.
Mr. Sawak.
It doesn't. Self-defense is a question that would be tried by the trier of fact as an affirmative defense. So at this point, it would not matter. And it can be used for impeachment, but it has to be crimes involving truth.
My purpose is not for impeachment, Judge. Let's be clear, the Self-Defense Act doesn't just require the trier of fact at circuit court to deal with the issue. Prosecutor must present some evidence at the time of warrant, at the time of preliminary exam, and at the time of trial that this was not in fact self-defense. I think it goes right to the heart of the issue.
That's the exam stage?
Yes, Judge. At the exam stage, I can pull up the statute for you. It's very interesting. I just litigated it 3 days ago. Okay, let me find it real quick. Yeah.
Right, so I was like, oh. Should we get an email? If I said, should be your email. You send it to me. Some really good stuff for you, man. Said she's in the number of photos. He's like, I just sent one yesterday, Judge, you put $1,000 cash on the asset rate reduction. The case is, right, not right now. Judge, you just- Thank you.
780.961. And for the record, it states, section 1, an individual who uses deadly force or force other than deadly force in compliance with section 2 of the Self-Defense Act, and who is not or has not or is not engaged in the commission of a crime at the time he or she uses that deadly force or force other than deadly force, commits no crime in using that deadly force or force other than deadly force. This is the section that's more pertinent. If a prosecutor believes that an individual used deadly force or force other than deadly force that is unjustified under section 2 of the Self-Defense Act, prosecutor may charge the individual with a crime arising from that use of deadly force or force other than deadly force, and shall present evidence to the judge or magistrate at the time of warrant issuance, at the time of any preliminary examination, and at the time of any trial establishing that the individual's actions were not justified under section 2 of the Self-Defense Act.
I'm printing it out for us. Okay, thank you. Great.
Yeah.
Unless they explain. Because it says there, the person having been brought to court having otherwise committed crimes. If you want me to sign an order, what is the motion? And then just go ahead and say, it's just a walk, I have it printed out. Oh, thank you. I said. Great. And why section 2 they're referring to? Right. Section 2 of the settlement.
Correct.
You have,
That's the statute?
yeah.
Yes, it's, I'll tell you right. Judge, it's 780.971 through 974. That's the whole act, and then 0.972, that's the actual section.
Yes, please.
So are you ready to move forward? Do you have a chance, or you need some more time?
Yeah, I'm ready.
If you need more time, it's fine.
Your Honor, I'm not sure what bearing, the witness wasn't charged with anything. And no charges, and quite frankly, he can't be asked about his criminal history other than it has to be something regarding truth, like stealing or lying under oath. I'm not sure self-defense is an affirmative defense, and that needs to be going in front of the circuit court. I don't see where it should be applied here at the exam stage. This is a probable cause here. And in fact, witnesses testified that he didn't use any, use of deadly force at all. I mean, he didn't use any force other than pounding on, the defendant's car. Okay. Where, the defendant is accused, and what we're here for, is firing a gun at the witness, almost, and his wife, almost hitting the wife, and we have a bullet that could have hit him, that's gone nowhere, to the ozone, nowhere to stop. So, you know, I object, my clients are, I'm sorry, the defendants, or the witnesses' criminal history is not perfect.
Just so the court's aware, I'm not using this to impeach. With the Michigan rule of evidence that my brother counsel is citing is relative to impeachment. I'm not using this to impeach his credibility here. I think he's done a good enough job of that already. What I think here is that Self-Defense Act is not a mere affirmative defense. As much as the prosecutor's office wants to argue otherwise, the legislature simply doesn't agree with them, as in the plain writing of the statute at the time of preliminary examination. They have to produce some evidence that it was not self-defense. I think because this is a self-defense case, and they're on notice of that, is that what my client or anybody would have known about this witness's aggressive tendencies should come into play. And I think that is completely fair. It's not for impeachment for this case.
So okay, so I understand what you're saying, Attorney White, but there's been no testimony presented from the people that I have heard from that show self-defense that would raise the issue of self-defense. So if this was the standard for every exam, I hope the people would always have to show that it's not self-defense, it's assaultive. Is that what you're saying?
Yes, well, put it this way, Judge, and I just litigated this. That's why I'm being so clear on saying it's self-defense, so that they are on notice and they do have to put in that evidence as long as I raise it. This statute is not just affirmative defense, it's an immunity from prosecution. If you look at the one section, it states if they can't disprove that, then they're immune from prosecution. It's not a mere affirmative defense like insanity or entrapment that we would have to present down at the circuit court. This is specifically the statute. This is the strongest affirmative defense statute there is because it gives immunity and it puts the onus on the prosecutor, especially once they know that we are stating it's self-defense, that they have to put on some evidence that it wasn't.
So I think the evidence that's been presented so far, the testimony says that the complainant did not have a weapon in his hand or a deadly weapon or has made any threats to show that this would rise to self-defense.
Well, Judge, I would have to disagree with the court because in his own statement that he wrote to the police, he said, you're gonna have to kill my ass. He tells him he has to kill him to get away. My client's in the car, he's sitting. We have this complaining witness who's standing outside angrily. My client never exits his car. That's been clear. Complaining witness comes out, starts yelling, acting like a fool on the side of the road. They're having it out. Of course, now they're exchanging words and he's standing. My client's sitting. I will tell you as a former police officer myself, you never want to be in that seated position when somebody's standing over you. Guns come out way too darn quick and shoot people way too quick. And in this case, this is exactly what's happening here.
We still got a testimony that deadly weapon or any type of weapon.
Correct, but I don't think the statute requires a deadly weapon for somebody to be in fear. For example, if somebody's in their home.
Or any behavior, including a weapon.
Okay.
And in the statement, then it be raises the question of fact, the trier fact, because what I believe when someone says, you have to kill me first, it could mean, I'm not backing down, but it doesn't mean that I'm going to kill you if you don't kill me first. So it can be interpreted several ways, and I'm not the trier of fact to determine. And he said that his wife was in the car, and that in my interpretation, that you have to kill me before you kill my wife or I'm protecting my wife. So that's just my understanding.
No, and Judge, that's a fair assessment because it can be taken multiple ways. I'm not disagreeing with you on that. But what it goes to show is it can be taken what way, it depends on what's in other people's mind, maybe my client or anybody else in the situation. And somebody's violent history of attempted murder would come into somebody's play if somebody's standing in front of me, I'm a sitting duck in my car, and somebody's here who's been charged, if not convicted of certain things, especially here in Wayne County. And he's at my door and I have a weapon and I have my wife or girlfriend or whoever in the passenger seat and I'm defending myself. I think it just it's relevant, not for impeachment, of course, but I think it's relevant to the case. I mean, he's been convicted, he can say we can move on. That goes to show that there is an issue of offense here, that's all. No, not in a preliminary exam, you wouldn't.
Right, so that's what my whole point is, we're not even dealing with some issue today. Well, I don't think it's appropriate based off of what I've heard.
No, I understand that, Judge. I think the statute, and I'm not trying to argue with you, I'm just trying to make my record for later.
Absolutely.
But the statute's very clear that they have to present some of this evidence at the exam, and I think his criminal history or violent criminal history and history of violence does come into play as to that whole matter. I think it also goes to some credibility issues too. I mean, but that would be impeachment, so it wouldn't come in for that.
Okay.
I mean, admittedly, you know.
I understand, and I'm allowing you to make your record. I am not going to allow that information to be entered in the exam.
Okay, fair enough. Fair enough, sir, to state that my client never exited his vehicle, correct?
I'm sorry.
He never got out.
Okay, and fair to say you got out of your vehicle, correct?
After he asked me to get out.
Okay, and then you approached his vehicle, correct?
Yes, sir.
Okay, and then you went up to the car, right?
Yes, sir.
And you were yelling, right?
We both were.
Understand, but you were yelling too.
Yeah.
You're in a standing position in the passenger window, correct?
Yes, sir.
There's a female in the passenger seat, isn't there?
Yes, sir.
Okay, and did you keep your hands up the entire time to say, I ain't got no gun or anything like that?
You can see that. I'm talking with my hands.
Oh, you're talking with your hands?
I'm talking. Me and him was arguing.
Understand. Do you have a coat on that then?
No.
So in January, you didn't have a coat?
I think my coat was in the truck. By me driving, by me being in the vehicle, I think the coat, I might have had my coat was in the truck, sitting in the truck. But at the time when I jumped out the vehicle, it was during the argument. So what I had on, like when I jumped out, I might have didn't have on whatever. When I jumped out, it was me and him after the words we had. Because he initiated for me to get out of my vehicle. He did. He said, get out.
Actually, it wasn't the words, let's clarify that. It wasn't the words of pull over and we'll work this out. Isn't that what was said?
I mean, he couldn't.
Somebody said jump out of your vehicle in the middle of the lane of traffic.
No. When he said get out, it was like this is an argument, first of all, this is an argument. So nothing was said real lenient. When he said, get out, pull over, whatever, he was inviting me out of my vehicle. Him. We was arguing window to window. I never had exited my vehicle until he invited me out of my vehicle. And once he invited me out of my vehicle, I jumped, I didn't pull over. I jumped out right there on the service drive. That's what startled him.
Yeah.
When I jumped out right there.
So he was startled, you agree with me, right? You just said
I startled him.
Yeah.
Because he was actually thinking that, yeah, we're gonna pull over. I'm like, no, we're gonna be right here where the camera is.
Okay. What camera?
The gas station camera.
Perfect.
He was trying to get me to pull over in the dark, maybe like by KFC somewhere like, because we're on the service drive. There's no really to pull over. So where he was trying to, guide me to, I don't know. I just jumped out right there where it was lights, cameras, where I could be, because I see the weapon. See, that's the thing about it. When I seen him with the weapon, it wasn't really like that. I know I'm on camera. And I don't have no weapon on me. I don't have nothing on me. I'm mad. And I was even madder when he pulled the gun out, because why is he pulling the gun out in a situation like this? I ain't showed you no gun.
And when the gun was pulled out, you kind of stayed there and continued yelling, correct?
Yeah, because at this point, sir, I got my wife in the truck. When the gun came out, see, you keep thinking it just, no, when the gun came out, I've been in the military, I'm thinking protection. I got my family with me. I got my wife with me. At this point, when I seen that gun, okay, like I told him, I'm out the vehicle. So that gets my wife out of harm's way. If he shoots this gun, he shoots me.
Let me be clear. Your wife's in the car.
Yes, sir.
You let your ego get the best of you. You get out of the vehicle to run up on him with your sitting wife in the car.
He's my cousin. I didn't see no gun.
Okay.
At this point, when he invited me out of the vehicle, sir, I didn't see no weapon. He's my cousin. That's like your cousin.
Give me 1 second.
To get out the vehicle.
Nothing further, Judge.
Redirect.
Sir, When those shots went off, what was going through your head?
When the shots went off, I'm thinking about the trajectory of the bullets and the angle, because I'm outside the car. And as he's trying to shoot, he's trying to pull off. So at the same time, I'm thinking like, what is he hitting? You see what I'm saying? Because he's trying to hit me, but he's trying to do some type of evil stunt move at the same time. And that's what, he the shooter, I think that's what kind of threw him off.
When those shots rang out, did you observe your wife?
Yes, sir.
What was she doing?
By me facing my wife, like turning toward the vehicle, my wife only could go, she's in the passenger seat. She only could brace herself up against the passenger seat. As he's shooting, because the first shot went at the angle of my wife and me. I'm this way, she's this way. So we both at the same angle, but by him trying to pull off, it went in between me and her, but it went at her more.
I have nothing further, Your Honor.
Nothing based on that, Judge.
Do you want to release, did you release? The courthouse if you
Oh,
like.
no, I'm waiting on my wife. I ain't going nowhere.
Any other witnesses?
No, Your Honor.
Just one moment, Judge. You know, Judge, actually, the defense would call the officer in charge of this case for brief questions that they need regarding evidence.
Do we have him here?
Not sure, what's his name? I think it's a her.
Yeah, I think you're right. Off the top of my head, I don't know.
Me neither. What's her name? Nicholas, oh, no, it's not, Nicholas Hunt.
Nicholas Hunt?
Yeah, Geo Nicholas Hunt.
Okay.
While we're waiting for that, officer.
Right now, Your Honor.
We're just gonna handle cases.
Okay. Yeah, no, I think it's my case.
This is case 2060697, the people of the state of Michigan versus Demario James Byers. Mr. Byers is charged with count one, only count one, police officer assaulting, resisting, and obstructing, set for exam today.
Edwin Milwaukee, CR438, appearing on behalf of the people.
And good morning, Your Honor, and honorable staff, Attorney Quentin Dox, P number 79657, my client, Mr. Demario Byers.
And your client is not present, correct?
Yes, he's not.
Healing for the people.
We asked that Kennedy KPS, Your Honor.
Okay, he has extensive his history here. So I will set it, I've already done this once, 2,000 cash, so he's posted that and not appeared today.
And he was on Zoom, Your Honor. I don't have any explanation what's going on. We do not. If I can get him in, Your Honor, before the holiday weekend is over with, would you additionally rethink the KPS?
So at the end of the day, the KPS is going to systems.
Yes.
And unfortunately, I won't be working tomorrow, Sunday.
Right, so at the end of the day.
It will have to be for the right judge.
Okay,
But if you can find them by 4:30, you can have them Zoom on and you can address them before it's entered in the system.
it would most likely be a waiver, Your Honor. All right, I appreciate you. Thank you.
Okay, so it'll be 2,000 cash.
Okay, thank you.
I'm sorry. $2,000 cash. Thank you. It'll be cash assured. Wait. What's my Jamelia and
Daryl,
They're on waivers.
no, just two of them. Attorney Hearn showed.
All right, we have to be careful. Housekeeping matters.
Fair enough.
All right, ready to call your witness?
Yes, Judge. The officer in charge of this case, defense would call Officer Nicholas, I believe it is. Nicholas Hunt, I'm sorry. Yes, ma'am.
Door open right here in front. Have you ready to wait?
Sir, just please state your full name for the record.
Police Officer Nicholas Hunt.
Okay. And how are you employed?
Yes, sir.
How are you still employed?
The Detroit Police Department.
And what unit were you assigned to in January of 2023?
8th Precinct Detective Unit.
Okay. And you know why you're here today, correct?
Yes, sir.
So you investigated the case of Arthur Brown, correct?
Correct.
My questions are narrow, very narrow. There was mention of green light video from a gas station. Is that something that exists and you recovered?
Yes.
Okay, so did you upload that to evidence.com?
Yeah, sure, evidence.com.
Okay. Okay. Okay, fair enough. That's all I needed. Thank you.
Any cross?
Thank you.
One moment.
Yes.
I'm the only lawyer you know who's going to call more than one witness in an exam. Ms. Tanisha Brown, who is present today, she is apparently the other complaining witness who called her.
Okay. And then I'll swear. First name, please. Right, say your name, please. Last name Brown? Yes. Brown, raise your hand. You swear to tell the truth, the whole truth, and nothing but the truth. Yes. Okay. Let me see right here. or who's up in front of you, and make sure you speak up to that microphone, okay?
Morning, ma'am.
Good morning,
Please state your full name for the record.
Tanisha Brown.
Okay, Ms. Brown, I'm just gonna turn your attention back to January 15th of 2023, okay? Do you remember about 7:55 in the evening what you were doing?
Yes, we were heading home, heading north on the service drive to Southfield.
Okay.
Getting ready to get on the freeway, and that's when we seen my husband.
Okay, and when you say we, who else is in the car with you?
Just me and my husband.
Okay, and your husband is Charlie Brown, correct? And is your husband driving?
Yes.
Okay, and you're in the front seat passenger, correct? So you see this gentleman, Mr. Arthur Brown, correct?
Yes.
And what action or reaction, let me just back up, what did you guys do in response to seeing?
When we got side by side, they kind of made eye contact, and they both rolled the windows down and began to exchange words. And I think Arthur said, "Well, get out of the car." And then so my husband got out of the car, and they continued to argue. And then I remember Arthur pulling up, like because he's on the left side, I guess he's going to turn left. But in the argument, he pulled up and kind of cocked his car to the right, shot twice, and pulled off.
So when you said he shot twice, that was when the car was pulling off, he fired 2 shots?
Yeah.
Now, prior to that, how long was this argument where your husband was standing outside of his window, meaning Arthur Brown's window?
He was standing outside of the passenger side, I believe, or back of the car, passenger side area. Like I said, they were arguing. I don't remember the exact words, but a lot of words been exchanged. Like I said, and my husband said, "Oh, I heard him say, yo, you have a gun? Get out of the car with that," or whatever. And I said, "I just pull it up." Partially right, shot twice. The first bullet hit the hood of my car. It hadn't been too much tires, it hit me. I just feel like he shot that gun with no regard to who was.
I'm sorry, say that again?
He shot the gun with no regard to who was in the vehicle. My husband was outside of the vehicle, but he proceeded to, like I said, turn and shoot twice with no regard to who was in that vehicle.
Okay. And so it's more of like random firing off 2 shots, correct?
No, not random. He was aiming at my truck.
Yeah.
Objection leading.
It's not random, no.
Okay.
Can you rephrase the question or restate the question?
Yeah, this is the answer. I can rephrase it. Let me think where we were now. When you pulled away, when you were pulling away, 2 shots were fired, correct?
Yes.
And when those 2 shots were fired, those were, one of them hit your car, correct?
Yes.
And one of them did not, correct?
I don't know what the other one, no, it didn't hit my vehicle.
Okay. Okay, that's all I needed, Judge. You're aware that there's a history between your husband and Mr. Arthur Brown, correct? When I say history, I mean contentious history, family problems.
I know it was from family issues, yeah.
And part of that's dealing with a plot of land, some state, southern United States, correct?
Yeah.
Okay. And there's been an ongoing dispute apparently about this plot of land for quite a while. Is that fair to say? And that's caused a lot of family tension, correct?
Yeah.
Let me ask this. Did your husband, if you're aware, make contact with Mr. Brown earlier in that day?
Not number.
So if he called from your phone number to Mr. Brown, you're not aware of that?
No, I'm not aware. I mean, the phones are in my name,
Okay.
so.
Oh, so it could have been his phone.
Objection.
I don't
Can't
know
Well,
in phone calls, so I don't.
Ma'am,
know.
one second.
Objection.
I'm going to explain that. She's not familiar with
Yeah, this is my first time.
or evidence. So Ms. Brown, the way it works with an objection is placed on the record, you have to stop talking. Okay, I know you don't know that. This is not what you do every day. So just make sure you stop talking when you hear objection. Then I'll make a ruling after the argument.
Okay.
You may be able to finish or you may not. Okay. So what is the objection?
leading.
Judge, actually, I was just gonna withdraw it.
Okay, okay.
It doesn't matter much. Yeah, she's doing great. I mean, she doesn't do this every day. So the phone that the cell phone that your husband carries, is in your name, correct?
Objection, relevance.
Okay, if this goes to relevance as to a call made earlier in the day, she stated she didn't make a call, obviously, and she wasn't aware from her phone. She volunteered that all the phones in her name. I'm just clarifying the phone that he carries is in her name. That's it.
I think it's been clarified already. She already answered all the phones in her name.
Okay, correct. Okay, thank you. I appreciate it. During this incident, your husband at some points were beating on Mr. Brown's car, correct?
Objection, leading.
It's not a yes or no or leading, it's simply asking if he was beating on the car. Let's see how that's
Yes or
leading.
no, would be the answer.
There's been no testimony that she said that Mr. Brown was beating up the car. So that would be.
So that's why I'm asking, what did you observe your husband hitting Mr. Arthur Brown's motor vehicle?
Yes, I did.
Okay, and it was during the heat of an argument, correct?
Yes.
And he was hitting the car pretty hard, correct?
Objection, because
What's the objection?
he's leading.
It is leading.
He's leading, he can't lead on direct.
That's true. Yes.
Okay. At any point, did you observe your husband move to the back of Mr. Brown's motor vehicle?
He was, yes, he was on the passenger.
Your Honor, he's leading again.
It's not leading to ask what she observed. That would mean that we can't ask the questions ever. That makes no sense.
No, it's your form of question then. If you gotta, what happened next? That's would be appropriate question.
So I've always allowed a little bit just to get through preliminary matters, but if there are facts that have been from Ms. Brown, where she stated that something has happened, it becomes leading if you're telling her what happened and asking her yes or no. So I would ask her.
Okay. We'll start from the beginning then. I was trying to make it easy. Well, I'll just start saying, I'll stop you. I'll just let you say, what happened that day?
We were heading home from getting something to eat. We were heading home. We spotted Arthur Brown on the left side of our vehicle. They had caught eye contact, rolled the windows down, exchanged words, told my husband to get out of the car. Husband got out of the car. Arthur never got out of the car. My husband, they were arguing back and forth. At some piece, so like I said, passenger side, rear, up in that area. My husband hit on the car, told him to get out of the car. And as I was ready to pull off, he cocked his car to the right a little bit, shot twice at my truck, and he pulled off.
Okay. And so that's all you observed. You observed nothing else, correct? And I'm sorry to ask it this way.
I observed him shooting at my vehicle. I seen two flashes coming towards me as he pulled off. That's what I observed. And he pulled off and went to the right.
Okay. So you observed flashes coming from the motor vehicle, correct?
Yes.
And so there's two people in Arthur Brown's motor vehicle, correct?
Yes.
There's a male and female, right?
Yes.
And you just saw the flashes from within that vehicle, right?
Yes.
Based on the court's ruling on the leading, I have nothing further.
Where did you observe the shots come from?
The driver's side of the vehicle.
And the defendant, he was inside his vehicle?
Yeah, he never got out of his car.
And what were you thinking when the shots went off? What was going through your mind?
Oh my God, he's shooting at me, and at that point, all I could do was kind of race. I was trying to get down in my chair, but I forgot I had my seatbelt on, so I couldn't go anywhere, so I'm just like this, praying that the bullets didn't come through the windshield.
I have nothing further.
Nothing based on that, Judge.
And Ms. Brown?
And with that, Judge, defense has no further witnesses. Thank you.
Oh, I'm sorry.
No, but wait, Ms. Brown was still.
Okay. Yeah, but for some reason I thought I heard somebody behind me, not you in front of me. Your Honor, people would request or motion that defendant be bound over on counts 1, assault with a dangerous weapon, count 2, the same, counts 3 and 4, weapons of felony firearm, added charge of assault with intent to murder as to Mr. Charlie D. Brown. And weapons, and another charge of weapons, firearm discharged from the vehicle, as well as the 2 more charges of weapons, felony, firearm regarding those. We would also motion to add charges, assault with intent to do great bodily harm to Charlie Brown, assault with intent to do great bodily harm with Tisha Brown, and as well as the felony firearms to go with those charges.
So is it my understanding that you want to add 8 additional charges?
Yes.
Totally, right, 4 from the beginning on notice and then 4 more after testimony.
Correct.
Mr. Swap, you ready to move?
Yeah.
Oh, I'm sorry.
Your Honor, this is, people have met the burden of probable cause hearing. Defendant, granted, neither party, the witness or the defendant, are angels. But Mr. Brown did not have a weapon. He was being challenged in argument by the defendant when he went up to the car, on the defendant's invitation, as according to his testimony. And during the argument, the defendant pulled a gun, shot at Mr. Brown, with the intent to do him, to kill him. Or at the very least, harm him. Bullets went off. One hit the truck, putting Mrs. Brown in fear for her life. The other bullet, God only knows where it went, and thank God it didn't hit anybody else. He shot within inside the car, and it's clear that he had intent to do harm and to assault the witnesses, complaining witnesses, with lethal force, which is what bullets. Neither Mr. Brown was not armed, and the defendant remained in his car, could have driven off at any time, but he chose not to. He chose to shoot at, Mr. Brown. So we feel that there's, enough to find the defendant over on all charges. Thank you.
Attorney Wendy.
Judge, with respect to all the charges first, under the Self-Defense Act, and we've already cited the sections earlier this hearing, they have to show some evidence that there was no self-defense in this case. I don't think they meet that, therefore my client should be immune from prosecution. That aside, people seek to add 8 additional counts, 4 counts of felony firearm, 2 counts of assault with intent to murder, and 2 counts of assault with intent to do great bodily harm, along with discharging a weapon from a motor vehicle. Judge, I would submit to the court that assault with intent to murder requires a specific intent to fire directly at somebody. It was accepting the testimony at face value. The vehicle was moving away, trying to escape. He had to shimmy, I believe the first witness stated, shimmy to maneuver his way around the complaining witness's car in order to escape. And he fired 2 shots in that time, one of which hit apparently the hood of the motor of Mr. Charlie Brown's motor vehicle. The other one went elsewhere. Again, Judge, I don't think that assault with intent to murder would apply here because there's no specific intent to murder somebody. He's trying to pull away and get away. And I think that'd be very inappropriate to bind over on assault with intent to murder. Likewise, assault with intent to do great bodily harm would have the same argument. That's specific intent crime. And the evidence doesn't meet that he said anything, meaning my client, approached, said anything, I'm gonna kill you, I'm gonna hurt you, anything like that. It was as he's trying to get away from this situation. I think it's been clear in this case that my client never exits his motor vehicle. There was crap talk, so to speak, between the two. And according to the complaining witness, he was invited out of his car, which for a guy who's so concerned about his wife, jumps out of his car to act that way in that fashion in the middle of length of traffic, shows that he was not even in reasonable fear. This guy told him he had to kill him at a certain point. All kinds of names, all kinds of things that were going on in that case. And so with that, I think with the totality of circumstances, specific intent cannot be met for assault with intent to murder or great bodily harm. Also, Judge, with respect to assault with intent to murder and assault with intent to do great bodily harm, this court cannot bind over on both. Reason being is great bodily harm requires them to intend to cause great bodily harm less than murder. They can't turn around and then say, but he also assaulted him with intent to murder. So those 2 charges would fly in the face of each other. And either the assault with intent to murder or great bodily harmless to murder, whichever one in the company of felony firearms should not be bound over. We think none of them should be bound over, of course, because there's no specific intent. But if the court was splicing it that way, that's where we argue. With respect to weapons, discharge motor vehicle, Judge, that doesn't require specific intent. And I think there's a question of fact with relation to that count. So also, admittedly, we would state there's a question of fact with counts 1, 2, 3, and 4, which is the felonious assault. Of course, that's with our Self-Defense Act argument. If the court doesn't accept that, then these are the arguments for what the court should and should not bind over on. Thank you.
Yes, with intent. Defendant pulled a weapon and shot the weapon, fired the weapon. Obviously, he intended to do something with that. So the fact, there's intent. He fired it. If he wasn't had no intent to do it, he would just driven off. So, and it's our position that there's enough to hold him on those charges. Find him over on those charges.
Okay, I will not be binding over adding a charge of assault with intent to murder. But for the remaining, would be 6 charges. Because there were 8 requested, I will not bind over on A1, which means that felony firearm count will not be bound over as well. I do believe that people have met its burden of proof and this standard, probable cause standard for assault with intent to do great bodily harm less than murder. With that charge, the people have to show first that the defendant tried to physically injure another person. In this case, we have a firearm that was actually discharged twice. And the question of fact would be for the trier of fact to determine whether he tried, but based off testimony here, I believe probably did. I don't have to deal with beyond reasonable doubt, so I have to stick with my standard. Second, that at the time of the assault, the defendant had the ability to cause an injury, or at least believe that he had the ability. And once again, a firearm is involved here, and that's pretty obvious that he had the ability to cause an injury. Third, the defendant intended to cause great bodily harm. Great bodily harm means any physical injury that could seriously harm the health or function of the body. In this case, a gun was used once again, and there's testimony that 2 shots were fired, and one actually hit the car in which Mr. Brown was sitting in, right on the hood of the truck with the windshield, which she stated it could have almost hit her. And I would bind over on 2 counts, as Mr. Brown testified that the gun was pointed to him prior to the shooting. Just because the bullets did not take effect to anyone or injure anyone does not mean that does not satisfy the elements for great bodily harm. And of course, that means that it was called a dangerous weapon. Those 2 counts will be bound over as well. With the accompanying felony firearm counts and then the discharging of a firearm from a motor vehicle, the people have to show, or had to show that first the defendant discharged a firearm. There's testimony stating so. Second, that he did so intentionally, that is on purpose. I do not believe that was an accidental firing. Third, that he did so from a motor vehicle. We have testimony that the defendant was in the vehicle, never stepped out of it. And fourth, that he discharged the firearm in a way that endangered someone else. And I believe there's testimony showing that. And Attorney White, I understand your self-defense argument, and I allowed you to place that on the record. I'm going to bind it over, and I know that you will continue to fight that issue. But I believe at this stage, the people have met its burden of proof for the 4 original counts and then the additional 6 counts that the people requested, which would be 2 counts of assault with intent to do great bodily harm less than murder, 1 count of discharge a weapon from the vehicle, and the 3 accompanying felony firearm charges. Anything else?
No, you don't. Nothing from defense, Judge.
Okay, so Mr. Brown,
Yes, ma'am.
you will be bound over to 3rd Circuit Court. You are out of custody, so it'll be 2 weeks from today for your arraignment on the information. It'll be June 9th at 9 to 5 a.m. Okay?
But I guess I'm leaving here, Mr. White.
I'll keep you updated. I'll meet you in the hallway to talk about it too.
It's sad to hear what's going on. This is a family issue. I don't know what contact you all need to have with each other, but at this time, I'm keeping the no contact order in place. Okay?
We don't.
I just want to make sure that it's on the record, because after I get off the record, I'm out of jurisdiction. Anything else after what I just said?
No, nothing from defense, Judge.
All right. Have a good week.
I'll meet you in the hallway.
The other,
The other one.
the other one. And she was gonna get you too. She's like, I know. How you doing? It's like, you have on the robe and everything, but I know he's not gonna.
So for Brown.
Judge? I mean.
Sure.
It may be helpful.
Okay. Okay. Good morning.
Good morning, again.
Yes.
Cause I saw you first thing this morning.
Seemed like it was yesterday.
Yes, I know. How you doing? Miss Ripley, this your
He's
case?
here for the 3-bedroom.
The phone number went through too, to Mr. You know what, they have you listed in there as Mr. Hearn. And
I
then,
fixed it.
we was like, we don't know who that is.
I fixed Mr. Hurd.
Yeah, I finally got the phone
number.
That's Mr. Hearn. Yeah.
was walking through the door. Yes, I fixed everything. But we were in the middle of exams, so I couldn't. I guess we could do the waivers and.
Okay.
Well, she needs to go on break.
That's not who they had. You called me? Oh, Lord. Today?
Yeah. Just in case.
No, because he was probably asking, look out for him.
Yeah, do you need me to sign the first, second and third defendants waivers?
He's like, I called you this thing. I know.
That's Mr. Ripley, I'm sorry, yes, so here. No, Ms. Parrish.
Yes.
Do you mind if we go on the record without you?
No,
Or the 2 waivers?
100%, no objections,
Okay.
and I've already spoke to, both, defendant 2 and defendant 3's counsel. In there, and I, it's emails from you guys.
Right.
As long as, because the arraignment's, 2 weeks.
Right.
Try to do, like I said, just to their advantage, so.
No problem.
I've already talked to my, I'll be right back,
Just
just went to the ladies' room.
Okay. Oh, wait, before you go. Judge, I'm sorry, you already fired? How did y'all were in the courtroom? Thank you. I didn't feel like that, but of course.
Right, right.
No, I don't. I know, I forgot. I have to show you after.
Oh, we want to see now.
I know, that's what I told her.
I know.
Right. She said she, I could put on the record. Well, I guess we can wait now. Waiver.
Okay. Oh, see, okay, see, you probably didn't even text it. I'm not talking that. I'm not talking that.
Oh, come on, girl.
I don't even have a text.
I'll never joke.
I was gonna say, what do you do? You can please.
If I don't have a text, what's popping? Because that's clearly. No, that's not. I know, but I'm just saying, so you know, I wasn't ignoring it. I don't have that number. That's just, I'm getting.
We should count. Well, that's it.
Yeah, I'll type that.
It's about 6 years. You know what? Because I always had an office camera cell phone. In the 21st century, I don't know why do I have an office? She's like, I read that. That was my number.
Good. Okay, we're gonna start without the prosecution. We have a.
But I got a bond, a question though.
Huh?
I have a bond issue.
You wanna do it off the record first or talk? Well, she's not here, so. We can do the waivers. Maybe she'll be in by that time. Ready? Okay. This is case 2356806, the people of the state of Michigan versus Michael Durham, defendant number 1, Jamila Jones, defendant number 2, and Daryl Durham Jr., defendant number 3, all charged with 1 count of police officer assaulting, resisting, and obstructing, set for an exam today. Appearances.
Good morning, Your Honor. Daniela Parrish on behalf of the people, PA 5495.
G. Whitney McGriff on behalf of Mr. Dormier.
And if it please the court attorney, Andrew Fanning, P 42853, appearing with my client, Mr. Jones.
Good morning, Your Honor. Carolyn Chapman Marsh, P 3188, present on behalf of Gerald Boone.
And I guess we'll start with Ms. Jones. Jamila Jones. For the both girls. Okay, thank you. All right, today's the day set for the exam. I have 3 waiver forms before me. Is it correct that all 3 individuals be waiving the exam today?
Yes, sure.
Yes, ma'am.
Yes, Your Honor.
Okay, any objection from the people?
No objections from the people, Your Honor.
Okay. To both Mr. Durham and Ms. Jones, I'm going to ask you all the same questions at the same time to save some time, okay? I need you to respond verbally, yes or no to my question. And if I hear that it's a question or an answer that I need to further explore, I will do so. If you can't hear me or if you don't understand me, let me know, okay? And you're going to say yes? Yes. Okay. All right. Ms. Jones, Mr. Michael Durham, Mr. Daryl Durham, is it your wish to waive your exam today?
Yes.
You all understand that you have a right to a preliminary exam?
Everyone needs to respond, so.
Yes, yes.
Thank you. Okay. And then if you were to demand an exam today, the people would have to show a probable cause standard, which is a much lower standard, it's still a standard in criminal law, that 1 charge I read off was committed in the city of Detroit and that you 3 probably committed that crime. You all understand that?
Yeah.
Yes. Okay. And that by waiving your exam today, that means that people do not have to present any evidence or prove anything today. You all understand that?
Yes.
Okay. All right. You all also understand that you're not waiving your right to trial.
Yes.
Okay. Did anyone force you or threaten you to waive your exam today?
No.
Okay. Did anyone promise you anything?
No.
Okay, I find all three waivers to be freely, understandingly, and voluntarily given. All three of you all are out of custody. We'll have the same arraignment on the information date of June 9th at 9:05 a.m. Frank Murphy, Hall of Justice. I know Attorney McGriffey, you want to address bond period.
Yeah, it's my understanding that Mr. Durham has a tether requirement. Your Honor, Mr. Durham indicates to me that he works or does have the possibility of working, and his bond and tether requirement right now requires him just to be at home. But I'm also asking the court possibly to consider just removing the tether altogether. This is a 2-year offense. He's highly eligible. The facts of the case don't allude to him being somewhere where he wasn't supposed to be, or late at night where he wasn't supposed to be at. I don't really see the need for a tether. I don't know if he has he shouldn't have any type of capious history of not appearing in court. He was here before me, of course, today. So I'm asking the court to consider just removing the tether, but if the court doesn't agree with me, I'm asking the court allow for Mr. Durham to be employed. He works the weekends at Ford Field.
Before I, who has the tether on?
Mr.
Okay. Only one?
Yes.
Okay. All right, anything for the people?
Your Honor, in response, I believe it is possible that defendant one situation with the tether results in probably the facts of the case that there was a alleged assault, actually, not just resisting in this. However, as defense has indicated, defendant number one show that he's employed, people do not object to modifying his tether requirement to allow him to go to work, but we will defer to Your Honor on this matter.
What days do you work, Mr. Durham, at Fort Field?
I work Sunday, Monday, and next month on the 9th and 10th.
And do you have stable residence right now?
Yes.
All right, so I'll have the tether removed. Of course, well, this is, you said it's from 2 years ago. I have yours from May 7th this year.
I didn't say that.
What did you say about 2 years?
I didn't say.
He
2
said
years.
that the maximum penalty on this particular case is a 2-year offense.
Oh, that's
And
what
that
I
his
said.
client is highly eligible, is what he said.
Oh,
You're welcome.
thank you.
Because I was confused. Thank you. All right, so I will have the tether removed. I'll sign that order. And you all are bound over to Third Circuit Court. It's no, I mean, I don't have to put no contact. I'll say it, but I don't think you are, no officers. That you doing. Anything else?
Nothing from me. Thank you, Your Honor.
No, Your Honor. Thank you.
Okay, thank you. Now, may